I'm Cindy Sullivan with Key Community Management. We're going to talk today about best practices for homeowners associations collections. We have with us Diana Kennedy, paralegal with Moretz and Skufca, and thank you for joining us, Diana.
Thank you.
Diana has been working for 20 years as a paralegal, working for HOA attorneys. So she's a great resource. We've worked with her a lot, so I appreciate you being here. So we wanted to talk about what we do briefly, and then how we work with a law office in terms of collecting assessments for communities. So it is typically a requirement for association members to pay assessments, whether it's annually, monthly, quarterly, and it will be based on each community's budget, and with everyone paying, that's how they cover their expenses, and the community can operate. So once an account is delinquent, we have processes in our office that we follow for sending customary letters of delinquency, and then we work with the board members to let them know about unpaid accounts, and then they would authorize an account to be turned over to an attorney as needed. So tell us what your office does when you receive a new account for collections.
Well, first I want to say thank you from Zach and the whole Moretz and Skufca team for having us here today and my attendance. What we do is as the paralegals, when the accounts come in, the attorneys have us follow a specific procedure, which is really mandated as well under the law. What we do is we first have to verify the debt and make sure that it qualifies for a lien to be placed on the property. We also make sure that the owner has had the proper notices, and we look at the notices as well as verify that all the addresses of record for the owner were found, and that all owners of the property are also included in those notices that went to the owners. And if all of those things have taken place, then we would move forward and file a lien against the property and notify the homeowner of the lien. We would serve the lien as well as send everything regular mail and certified to that owner, and hope that that owner will contact us. Usually a homeowner will contact us pretty quickly. They also see that they have incurred legal fees, which can start at $300 on up depending where in the process they are. So it can be a costly process for someone who does not comply and contact either the management before it gets to the law office or the law office on the first stage of the collection.
Right. So when you have an account and an owner contacts you, are you able to offer a payment plan? I know we offer that here when we are initially working to collect assessments.
Right, yes, we do. We do offer the ability to do payment plans in our firm. A lot of it is based off the latitude granted by the boards and what they allow us to do. Some boards will tell us go ahead and handle it anything up to 3 months, and other boards prefer that we request each time if a homeowner does come to them with a request. So we do work with payment plans in any stage of a collection, provided that the board approves the action.
That's good. So what have you found is your success rate of collecting really in that lien stage and not having to go further?
For the most part, I would say half of them pay in the first part, and the other half that don't, that go to the next part, then that half of them will pay in that next part, being a foreclosure being filed. And prior to even getting to that next part, if someone hasn't paid, we are going to look more closely at their title. We want to make sure that there's not a bank foreclosure or something else going on at the property prior to getting to that next step. But generally, the next thing that would happen most likely is going to be a foreclosure action. And I find that then half those people will call and they'll work it out and pay, and then there's that last little faction that maybe had not contacted us at that stage, but perhaps contact us at the end stage. Very few that we have seen, very few go all the way to the end stage where it would end up going to an HOA. Or anything like that, or a third party.
Right.
That's a pretty rare occasion.
So it's interesting, residents always comment how they feel the HOA has a lot of power to take their home, right? Just like a mortgage company can. So it happens. It is rare, right?
That for it to go all the way, it is rare. You have a situation where somebody is either extremely stubborn and does not want to pay, or there are situations where HOAs will move forward on something, whether or not it may be a good deal. Sometimes a house is abandoned and maybe somebody doesn't know that nobody is there to receive foreclosure papers. If somebody is living in a home and that's where they lay their head each night, it's most likely they're going to call and want to work it out. And our firm is always available to help homeowners. We want to help the homeowners to get in compliance and stay in their homes while meeting our ethical requirements to the client as well with collecting their funds. And they don't need to be owning homes either. So
it's a good point. Well, and I think what we appreciate about working with Moretz and Skufca is you advise us, and then we advise the boards when there is a good candidate for foreclosure and when there isn't, because you're looking, you know, up to the minute. Is there any pending action as far as bank foreclosure? Have they paid their taxes? You know, is it occupied, right? Is
Right.
it vacant? What's going on? Because you can't always make that decision just based on, well, they owe $1,000, let's do it.
right, you want to look at everything, is our philosophy, our attorney's philosophy as well, that we look at it all, let's make the best decision for that situation.
Yeah, that's very good. We appreciate that because you want to make sure you can collect the funds at the end of the day.
Right.
And not lose on what you've spent in legal fees.
And that doesn't mean that you're going to not take some action against somebody else. Maybe their circumstances are different. The HOA has an equal responsibility to all members and all delinquencies, and therefore, but we look carefully as we are doing these things to make sure that it has the best possible outcome that we can try to help you get.
That's great, right? So it's always that education aspect, right? Learning
Right.
the knowledge about the particular situation. We work with our boards to educate them on the process. What is their duty? Can they pick and choose, you know, depending on certain things, you know, so we want them to know, really, they have requirements they have to follow. So one thing too is it's a question we get sometimes, hey, you know, what is the effect of a lien on someone's, you know, other parts of their life? Like, how can it affect them negatively?
Sure. Well, they can't sell their home in most cases without satisfying the lien. A lot of times it gets satisfied at a closing table, and that's fine as long as the lien is satisfied. Many lenders will not refinance if you don't have it paid off. I have seen in some cases where people are trying to modify their loans to avoid bank actions, and the banks require them to pay that prior to a modification being allowed. So it can hold you up if you don't, take care of it and make sure it gets paid and do what you're supposed to.
Well, that's good. That's what we want, right?
Yes.
We want them to be held up until full payment is received. Thank you very much. Key Community Management is our address, 1201 Stallings Road. Send us your money. So, well, I think that's good. You know, so the processes are in place, and they're successful. They work.
The process works,
Yeah.
and there's no doubt about that. And I think if every board equally followed their straight policy, having good policies in place, following the policy straight, working together with their management and law office, there's no reason why they can't all be successful in their financial goals.
Mm-hmm. That's right. Consistency is the key. You know, It's what we find, even as leaders change on the boards. So we want to talk about our question of the day, and we've been getting some calls this time of year, assessments that come due the first of the year, and some folks are asking, hey, can you send us a reminder every month regarding when our assessments are due? And these particularly were some folks that pay quarterly, and we knew that we send them a coupon book for paying, and so that's our process. So we found it interesting that they couldn't maybe create their own process for remembering.
Right.
So what do you think about that?
Well, I talked to Zach a little bit about this, and the other attorneys, Mr. Gelwicks and Mr. Carb at our firm, and one thing that they felt it was important for me to share with you was that an HOA and management company, whenever you are collecting debt, money that people owe to the association, you become a debt collector. Sure. And there are specific debt collection practices that have to take place. There are things you can and cannot do. So by following 47F or 47C and sending the letters through first-class mail, and in the process that's neatly set up under the statute, you run a cleaner situation as opposed to putting yourselves in a position that you could break some federal requirement under Fair Debt Collection Practice Act.
Right.
So it's really important to know that, yes, you are a debt collector. You are responsible for communicating with homeowners in a certain way, and since the practice of sending a 15-day letter when somebody is delinquent is a good statutory way to go, you know, keep that in mind.
U.S. mail is how we're sending notices, right? And generally, we're not going to email reminders or send statements every month when a bill has been sent.
And that would, again, be your company's, you know, preference on doing things. It certainly would be our preference on that, because we would then be able to have a clean, clear document of what has transpired with a case, what you've sent to them, and so on.
Right. And just to clarify too, when Diana was referring to 47F, 47C, those are North Carolina general statutes, and they're available to view online, and they govern condominiums and single-family homeowners associations.
That's right.
So, well, thank you very much. So we hope you've learned something today. Call us anytime if you have questions about your community. Reach out to Moretz and Skufca. They are
We're here for you.
Wonderful group of folks with a lot of knowledge. So I'm Cindy Sullivan, once again, from Key Community Management. As always, we're here to help you make your community great.